Hi, I'm Max Dilendorf. I'm a digital asset lawyer based in New York. I've been working in tech and digital asset crypto space since 2017, and over the years, I've handled more than 130 arbitrations across JAMS, NAM, and AAA. These matters include breach of contract and hacking claims, software and smart contract liability disputes, and protocol failures. Our practice also covers SIM swap and account takeover claims against carriers such as Verizon, AT&T, and T-Mobile, as well as merchant disputes with payment processors and AI compliance issues. My arbitration practice focuses on three main types of clients. First, software and blockchain developers involved in disputes over code performance, integrations, service level agreements, or software bugs that lead to significant financial losses. Second, Web3 founders and crypto projects dealing with token issuance, governance, and investor disputes. And third, victims of cybercrime and crypto theft, including SIM swap victims who are looking to get recovery through arbitration after exchanges, telecom providers, or other service providers deny liability. We also represent merchants in disputes with payment processors like Stripe, PayPal, American Express, and other acquiring banks, including account terminations, frozen funds, and match list placement or removals. Like many other claims that I've described, these disputes are typically governed by mandatory arbitration rather than court litigation. And one of the biggest mistakes I see is that parties treating arbitration as if it's just another version of federal or state court. It's not. The rules are different, the procedures are different, and the strategy needs to start much earlier. How you draft the arbitration demand, which rules apply, how discovery works, and if motion practice is even available can differ dramatically from traditional litigation in federal or state court. The first major decision in any arbitration is choosing the right forum and the right arbitrator. So you've got three options, AAA, JAMS, NAM, and they all operate differently. Their rules, fee structures, timelines, and arbitrator selection processes are not the same, and those differences can directly affect cost, timing, and outcomes. In many crypto and software liability cases, parties simply accept the arbitrator list. They're given without meaningful analysis, and that could be a costly mistake. Arbitration offers something you never get in court, a real say in who decides your case. In crypto, software, smart contract disputes, that matters more than anything else. You want an arbitrator who understands technology and software, DeFi, smart contracts, and AI-related industry standards. You don't want a construction or employment arbitrator learning technology for the first time in your case. At the same time, you need to strike arbitrators who are not the right fit for your case or your overall strategy. When my firm gets involved, we look at three layers of strategy at once. First, we analyze the arbitration clause itself, examining the form, the applicable rules, and the degree of procedural flexibility. Second, we focus on the arbitrator selection, ranking and striking candidates based on their technical background, potential biases, and prior track record. And third, we map out the case roadmap within each forum, because differences in timelines, discovery tools, and motion practice can materially affect your chances of success. This level of planning is especially critical in software liability cases, crypto, and smart contract disputes. These cases often involve complex transaction histories, expert witnesses, software code, and cross-border issues. And you really need an arbitrator who can follow that complexity. That's why we are often brought in, not just to argue the case, but to help design the strategy from day one, who to file against, who to disqualify, and how to present the evidence. If you are a software developer, a Web3 founder, a merchant facing a payment processor dispute, or a victim of a crypto-related cyber incident, getting the arbitration strategy right early can make a real difference. If you would like to discuss the dispute, my team and I consult on arbitration strategy across GEMS, AAA, and MEM. Thank you for watching, and I will see you in the next episode.